So what is likelihood of confusion? So in the trademark world, likelihood of confusion is something we're always thinking about, and here's why. So if you are a business or have a product out on the market and you have branding on it, you have a name, logo, maybe slogans, all of those things potentially are trademarks. If they're things that your customers are recognizing as being your brand, then and meaning that that thing comes from you, then that is a trademark. That's literally what a trademark is. So when you are using something as a trademark in commerce, if your trademark is too similar to someone else's, is confusingly similar to someone else's, and is meaning it is likely to be confused with someone else's branding, that means that you are potentially, probably infringing their trademark. So this is why we care. Likelihood of confusion determines whether two trademarks are interfering, are likely to be confused. And in the case of two trademarks that are likely to be confused, that means the one that was first in that region, or the one that was first registered, first filed at the trademark office. That, when I say the trademark office, I mean the United States Patent and Trademark Office. That is going to be the one with superior trademark rights. So that's going to be the one that is infringed, and the later one is the one that is infringing. Timing is everything. Doesn't matter who made it up. It matters who was first to use it in commerce as a trademark. So it all comes down to likelihood of confusion. So you can have two marks that are the same exact mark, say Apple, and they might not, just because it's the exact same mark doesn't mean that they are infringing or likely to be confused, which may seem strange to you, but think about this. Apple computer, we know, Apple electronics, Apple computer, whatever they call themselves now, we know that they make all these devices, the iPhone, etc. There are other companies named Apple. I happen to know of a child care provider, helper in Bucks County, and there was an employment agency, at least in California, and I'm sure there's a lot of other preschools and whatever called Apple. Nobody's getting those confused with Apple, the maker of iPhone, because they're just wildly different areas. So even though Apple's a very famous brand, so two marks can be identical and not infringing. The reverse is also true. Two marks can be different but yet infringing. So, and a lot of times people think, well, if I just add words, then it won't be infringing, right? Well, that's not necessarily true. If I wanted to set up a store called, Catherine's Nike store, that's not okay. I can't use Nike in the name of my store. And that would be a dumb name anyway. But Nike is obviously another famous brand. You can't use Nike Doylestown boots. That's not going to work either, because Nike is a famous brand. And also because Nike is associated with shoes, and it's as a standalone thing. Like, adding words to it is generally not going to get you out of confusion if you are in the same realm. Even Nike shoe repair, let's look at that one. Nike shoe repair also, I think, would be infringing because they are associated with shoes, and even though they don't, to my knowledge, do shoe repair, if I were to see Nike shoe repair, I might think, hey, I guess Nike is endorsing this shoe repair place. Or maybe Nike got into the shoe repair business. So be really careful. Realize that likelihood of confusion is something that a machine cannot do. It's actually something that two lawyers can disagree on. So it's important to not make assumptions about marks, whether they are infringing or not infringing. So I hope that was helpful. Catherine Cavella, IP Works Law. Thank you.